Ms. Nichols. So this is case 23-1043. People said Michigan versus Jacob Stanaway. And for the record, Ms. Nichols.
Thank you, Your Honor. Tara Nickel from the Ingham County Public Defender's Office. On behalf of Mr. Stanaway, we are both appearing via Zoom. Today is the date and time set for a plea hearing. Mr. Stanaway will be pleading guilty to count 2, reckless driving, and upon successful plea, the prosecutor's office will be dismissing count 1.
Okay. The reckless driving is 93 days, $500 fine, and it seems to me that that is actually also 6 additional points in the record.
Yes, Your Honor, it is 6.
That can actually be very significant in a way, because if you already have the record, it could cause you to have some sort of adverse action on your driving license privilege. It also probably cause you to have an increase in your insurance costs. In addition to, could present a violation of probation if you are already on probation. I don't know that you are, but you need to know that there could be those sorts of collateral or additional consequences. So understanding what I've said, do you still want to go forward?
Yes, Your Honor.
So 93 days in jail and a $500 fine or possibility. Actually, the fine would probably be more, or probably be closer to over $1,000. If I'm doing the math in my head correctly, it's probably more around somewhere $1,200 to $1,400. So understanding all that, you still want to go forward?
So I'd have to serve 93 days in jail?
I said it's possible.
Oh,
that
okay.
there is something that happens like a violation in addition.
Okay. Okay. Yep, I still want to.
Raise your right hand. Do you swear or affirm that the information that you're going to provide to the court will be the whole truth?
Yes, I swear, Your Honor.
Lower your hand. Want to make sure that you're doing this voluntarily. Has anyone threatened you or forced you to get you to do this?
No, Your Honor.
Has anyone made any promises to you to get you to do this?
No, Your Honor.
So you're pleading guilty, sir, because you are in fact guilty?
Yes, Your Honor.
And this is your own personal choice. I mean, you talk to your attorney about this, but this is your choice.
Yes. Yes, Your Honor.
And if I enter this plea, you're going to be giving up some of the rights that you have as a defendant. Ms. Nichols, I'd like to ask Mr. Stanaway some questions.
Mr. Stanaway, I'm going to take you back to June 5th of this year. Do you recall being at the intersection of West St. Joseph Street and West Waverly Road in Lansing Township, Ingham County, state of Michigan?
Yes, I do.
Okay. And were you operating a white Chevy Cruze at that time?
Yes, I was.
And did you make contact with a gold Ford Focus at that intersection?
Yes, I did.
And did you hit that vehicle intentionally?
No, I did not.
Okay, how did you make contact with the vehicle?
I tried to stop and I accidentally rear-ended the vehicle. I did not intend to crash my car that was, you know, close to being paid off, and my girlfriend's car of 8 years that was close to being paid off. I never intended for that.
Okay. And after you had made contact with the vehicle, you did not remain at the scene?
No.
And you did not call police immediately after noticing that there was potential damage to the other vehicle?
No.
Okay. Your Honor, I don't have any further questions for Mr. Stanaway.
Whose car was it that you hit, Mr. Stanaway? And how do you know?
We had been together for about 8 years and 1 week at the time. Boyfriend, girlfriend.
So this is she still your girlfriend, or is she your former girlfriend?
We haven't talked since the incident because of no contact, so I don't know at this point, but we had been together for 8 years, so I don't know.
Okay. And you do know that under state law, you're required to stop and contact the police to let them know about the accident.
Yes, Your Honor.
Okay. All right, I find that this matter is properly within the jurisdiction of the court, having occurred in Lansing Township, Ingham County, State of Michigan, on or about June 5th, 2023. I further find that the defendant has knowingly, intelligently, and accurately provided the court with sufficient factual basis for the court to find him guilty as charged with reckless driving, and pursuant to the agreement reached with the prosecutor, the court is going to dismiss count 1 of the complaint, which is failure to stop at the scene of a personal injury accident. Ms. Nichols, has the court complied with the court rules and taken the plea?
Yes, Your Honor, it has.
Do we have a restitution figure for the damage to Mrs. Martin's car?
No, Your Honor, I spoke to Ms. Cisneros this morning. She did not have one. I'd asked the court to reserve for sentencing, and Ms. Cisneros can present it to the court at sentencing.
Okay. All right, so does counsel believe that the court has complied with the court rules and taken the plea?
Yes, Your Honor, it has.
All right, so this is case 23-1043. People State of Michigan versus Jacob Stanaway. Appearances for the record, please.
Good afternoon, Your Honor. Elena Cisneros on behalf of the people.
Good afternoon, Your Honor. Tara Nickel from the Ingham County Public Defender's Office on behalf of Mr. Stanaway. Mr. Stanaway and I are both appearing via Zoom.
This is the day and time set for sentencing with respect to this matter. I've had an opportunity to review the assessment report. I believe the report to be factually accurate.
Yes, Your Honor, we do believe that the report is factually accurate. There are no changes that need to be made.
And Ms. Cisneros, do you believe the report is factually accurate?
Yes, Your Honor.
Mr. Stanaway, do you believe the report to be factually accurate?
Yes, Your Honor.
So ordinarily, we don't have the assistant prosecutor with us, but she's here and she's brought friends with her. And I'm going to guess that one of the friends is a young lady. Her name's Sarah.
Yes, Your Honor. And she does have her family here for support as well.
Okay. Sarah, would you like to talk to me? Please, come on up. So I'm Judge Allen and you're Sarah.
Yeah.
So Sarah, are you the author of this 2-page letter that I just read?
Yes, sir.
Well, you didn't sign it, so I wasn't sure 100%. So I'd like to hear from you. I always like to hear from people that are involved in the cases because, you know, I get a few pieces of paper when I get a case, and it's like snapshots of when somebody actually knows the parties that are involved. It's like getting the whole family profile, so you get a wider perspective of what's important in terms of what the court does for purposes of trying to do what's necessary. And one of the things that I want to explain to you, just to give you a little bit of context, is that try to figure out what needs to happen as a result of what has happened. And so you can go a long way towards telling me about what happened because of your involvement in this. And I know from reading 2 pages that I have that there's a lot that was not said as a function of this. And seemed to be consistent with what I was thinking about the case, more detail, of course. You to just feel comfortable to be able to speak from wherever it is. If you feel like you have to read something, I don't usually like people to read things. I just like to talk to people. But if you feel like you need to read because it is so burdensome to you, what you've been through, then you can feel comfortable to do that, but understand you don't need to do that because I've just read
Right.
this letter and it's fresh in my mind. And as I said, it already sort of dovetails into what I was already thinking about the case.
Okay.
So you can just start wherever you might start.
I would just kind of like to talk about that night more than anything, the night of the accident.
Well, it wasn't an accident, was it? It was a crash. It was a calculated crash. It was a crash that was born out of a situation that involves escalation of behavior. And it escalated because, quite frankly, you were dealing with somebody that was a bully that began to do more bullying behavior as he tried to control what was going on, which is not unusual in situations like this. Mr. Avon, if you have the need for some tissue, please.
Your Honor, sorry.
No problem. There's a reason we have tissue all over the courtroom. It's not unusual for people to be emotionally distraught. So please start wherever.
The night of July 4th, the night was amazing. I had had the day off of work and
What do you do for a living?
I'm a cosmetology educator.
Okay,
I work at a school in East Lansing.
because I noticed it said something about students in your letter to me.
Yeah.
So I wasn't sure what it was that you teach.
We were having a really good night and everything was, we were watching some fireworks. And
But he was intoxicated,
yes,
and he was intoxicated after having been in a situation where he had been involved in brutalizing you the day before and the day before that. And it seems like the type of brutalization was increasing in terms of intensity.
yes. So July 4th was kind of the day that I had said enough was enough and that I was going to take my leave from the relationship. And it was really then, I generally work very long hours, at least one day a week, at least 14 hours a day. So after I had left work on my 14-hour day, I came home that night and he was intoxicated. And I had decided to sit down with him for a moment and tell him that, we're done. I can't do this anymore. I've tried and tried. I tried and I couldn't do it. I couldn't do it anymore. So I had packed a bag and I had tried to leave and Jake had blocked the door and we were fighting and just arguing verbally, and finally I made my escape. I ran outside and I'd been able to throw my suitcase in my trunk that I had packed. And by the time I got to my car door, he was standing in front of it and blocking me so that I couldn't get in my vehicle to get away.
8 years. One person. And that's the years past, things sort of unwound. What are you doing for yourself, for your own self-care, so that you heal? Sounds like you're going to a counselor.
I do. I see a therapist regularly. And I've been looking around for like support groups and things like that as well. But basically we had argued some more. We had a carport attached to our house and he wouldn't let me leave. And then finally he had said, good luck getting anywhere. I'm gonna grab my screwdriver and I'm gonna slash your tires. And so he ran inside to grab something to supposedly slash my tires.
He actually was found with a large screwdriver in the front seat of his car, actually on the front floorboard. He told the cops that it was because he's a carpenter or something.
Yes, he is as well.
But that's not, I saw what you said about, he said specifically he was going to go get a screwdriver, so he did.
I then took that opportunity to get in my car, and I had driven left out of our trailer park, and I was stopped at the corner of Waverly and St. Joe. I was stopped at a red light waiting to turn left. And I was just so anxious, and I just remember seeing headlights coming up behind me, and I was like, there's no way that's him. Oh my God, that's him. Oh my God, he's gonna hit me. And then he then rear-ended my vehicle. I believe the police report did say that it was between 45 to 50 miles per hour while I was at a dead stop. I then immediately dialed 911, and he had gotten out and checked over and then got in his car and had taken off. And I just remember like so much happening at one time, and between the fire department and the ambulance and the police officers and everybody, and it wasn't really until my family came to pick me up that I really kind of understood what had happened. But my family was extremely helpful and loving and supportive when that happened. So this is one of the hardest things I've ever had to do.
Why is that?
I don't know.
Is it because, as you said in your letter, you felt like you have to be brave at this point?
Because I know that it's going to help me with my own healing if I do this.
What I like is that you actually spoke on behalf of other people connected to you too. You talked about the fact that you've got, relatives that you're concerned about, and students that you're concerned about being able to see from your example, that you've got to take steps to be able to, supposed to be somebody else's person that they're imposing upon you what it is that's going to be your life, as opposed to what it is that you want for your life. And they're using violence and the threat of violence to try and exercise power and control over it. So it's very brave of you to be here to a court of law without the lights on and people around and having to tell your story to complete strangers. So I applaud your bravery for being here and being willing to do that, because in a lot of situations, and we'll just call this what it is, it's domestic violence. It's domestic violence is what it is. It's not an unfortunate car accident. It was a calculated collision by somebody who was trying to exercise power and control over you. And he was willing to do anything to show you that he could control you and that you couldn't leave him, not without there being some consequences. And you said, damn the consequences. I'm here and I'm done with this, and this is going to be the signal for me. This is my inflection point to show that I am going to be who it is that I'm destined to be without him.
Absolutely.
So I think I have a little bit of an understanding of what you're dealing with. I don't know your whole story, and I'm not trying to pretend like I do. I just want you to know that you've been hurt. I've hurt you, and I understand what's going on. And I just have one question for you, and that is, what is it that you'd like to see happen?
I would like him to get the help that he needs. And I would really prefer no contact.
All of those things are easily accomplished by me. And if he were to have contact, if he were to call you, if he were to send you an email or a letter or a text, even if he were to just show up on the sidewalk or across from where you live at, no. And we will handle that. You'll be dealt with.
Thank you so much, Your Honor.
Anything else you want to say before I let you go? Who are the people that came with you today?
My family.
Is that your dad?
Yeah.
That's in the middle of glasses.
Yeah. They look a lot alike.
Yeah, I could see the little family resemblance. I'm sorry. And who's the young lady?
That's my younger sister.
And the gentleman is.
That's my boyfriend.
So thank you guys. And I know that you were actually leaving to go to your dad's house. It's a sanctuary for you when things were getting out of control. So it's good for your dad to see that you have that kind of confidence in him being able to protect you, and he's here with you today. That's part of this. This is actually part of the healing process too. To come and do this. So I'm glad to be able to meet the member of your support group. Okay. You can go have a seat.
Thank you so much.
You're welcome. Stay as long as you want. Mrs. Nurse.
Thank you, Your Honor. As the court indicated, there is a large amount of underlying domestic related issues, for lack of a better word, that really, in my opinion, paint the picture here. As the court is aware, I believe the court is aware that Mr. Stanaway was, once he was found by police that day, he did submit to a preliminary breath test, and he was a 0.24.
But they didn't have him driving, so they could charge him with that.
Correct, Your Honor. I am, and I did indicate this to Sarah as well before today, that I think that this is a blessing in disguise for her. I think that she's very lucky, and I think that Mr. Stanaway is also very lucky, and I hope that this is a blessing in disguise for him as well, that no one ended up seriously hurt. But I would ask the court to certainly impose a term of probation that would include addressing those underlying issues that have led Mr. Stanaway here.
Can you send that note to Denise and to Emily that I want Emily to be assigned to the case? So, Miss Nichols.
Thank you, Your Honor, and thank you
Go
to
right
Ms.
ahead.
Thank you. And on behalf of myself and Mr. Stanaway, I would like to thank Ms. Moran, excuse me if I mispronounce your last name, for coming and sharing your story. I can say that Mr. Stanaway certainly understands the seriousness of the actions, that this could have been a more serious case that I would be handling for him under just a reckless driving case. There are, as Mrs. Narrows mentioned, some underlying issues that go back beyond just this incident. Mr. Stanaway has admitted to me on many occasions that his actions and how he just chose and made a choice to handle the breakup was not the appropriate way to do so. And when I reviewed the assessment with him and saw that the probation department was recommending him to get some help, get some CBT, that is certainly what I think will benefit Mr. Stanaway and prevent him from coming before the court again in any future capacity. And I would certainly ask the court to, if it feels appropriate to assign him to Ms. Fabry, I leave that to the court's discretion, and would ask the court to put Mr. Stanaway on a term of probation to address the issues that brought him before the court. And I'll let Mr. Stanaway make other statements he wants to make at this time. Thank you.
Mr. Stanaway, you weren't really forthcoming when you spoke to the police. You weren't really forthcoming when you spoke to the assessor. I don't know if you're planning to be forthcoming as you speak to me, but obviously I already know a lot about certain facts and circumstances beyond the case. So you can just take it wherever you want to take it at this point.
I just want to apologize, Your Honor.
Fine.
I never meant for an 8-year relationship to end in a financial struggle, and I never meant to get into an accident with her. Her car was almost paid off, and so was mine. You know, I never meant for any of that. We were in the process of buying a house one to 2 months before that, and we backed out of one year before this month. Never intended for any of this to end that way, and I'm sorry to Sarah. She's an amazing girl, and you know, I'm nothing but sorry.
So you notice that you have said absolutely nothing about the terror that you put her through. That everything that you were talking about has to do with money. Financial hardship or breakup that you're concerned about, what it would cost to have the car repaired. Nothing about the damage that was done to her.
I am sorry about that. I never meant to.
Yes, you did. Everything you did was intentional. You were pinning her to the ground and beating on her. You blocked her from being able to leave you. Those are all intentional actions, sir.
I just asked her not to, you know, if we could talk. I wasn't blocking the door. I was simply asking her to talk. And
so I'm just going to call BS, because that's what you're saying is BS. It's a bunch of BS. A big guy, she's a little girl. You didn't have to do that. But you were holding her down, and you held her down many occasions. In fact, you choked her a few times. So I don't want you to insult my intelligence by trying to hand me a load of BS, because I just told you I've read all of the stuff about your case. This was your opportunity to show that you actually have learned something as a consequence of the behaviors that you've engaged in. You just whipped on that opportunity that you were given just now. You need to understand something, and you need to understand something very clearly. I am the person that will be supervising your file. You are going to be on a period of probation with me. And you cannot try to BS me and think that it's going to work. It will not. It will be better for you to understand that you don't have power and control in this situation. That you've given up to your power and control by virtue of becoming a person involved in the criminal justice system. Power and control lies with the judge. But even at that, I will tell you that what Ms. Nichols said at the outset can still be true for you. She said that this can be a blessing in disguise for you. And I don't know that you understood what she said, but when she said it could be a blessing in disguise, she didn't explain it, but I will explain it to you. This is an opportunity for you to kind of pump the brakes in your life, to put the brakes on and say, how did I come to this point in my life? And is this really respectful of who it is that I say I am? And if you actually look at your life in that light and say to yourself, I have to become a better version of myself, because this is not representative of who it is that I claim to be, then this could be the blessing because it forces you to look at yourself with clear eyes, which is what I'm doing, because I call BS on you every time. And when I do that, there is going to be a breach of trust, and you do not want me to be in a position where I don't trust what you say. You want me to trust what you say. But understand that even if I trust what you say, I'm still going to verify it. So this can actually be a blessing in disguise for you, but not if you think you're going to be allowed to go around and just say things that aren't true, that aren't supported by facts. I'm all about facts, and I'm all about a clear-eyed look at the facts around me. And you should have been able to glean that from my conversations with her. You were paying attention, or at least you should have been paying attention. You're lucky she didn't say I should throw you in jail, because I would have. She said so. But what I'm going to do is I'm going to place you on a period of probation. Probation is about you actually understanding that it's a privilege. Because the law says I could throw you in jail today, but she didn't ask me to do that, so I'm not going to do it. I'm just going to save the jail time at this point. But understand that there is a problem with probation. You will be going away to jail. I have absolutely zero hesitation about punishing the person with jail time. And you can lose your job, you can lose your housing, you can lose your car because you're sitting in jail. But you know what? You've handed me keys to the jail cell because right now I'm giving you an opportunity to stay out of jail by actually doing what's required of you, understanding that probation is a privilege and that you have an opportunity to change the future for yourself. But you might just decide not to do that. And if you don't decide to do that, I'm going to call it BS on whatever it is that you're doing, and you're going to go to jail. I hope I'm making myself clear to you.
Yes, Your Honor.
Yes. All right, 12 months probation, a $500 fine, $125 state assessment, $575 in court costs, which I find to be reasonable based upon what it costs the court to handle cases like this. And so what we do is we add up that total cost for all of our defendants, and then we divide it by the number of defendants, and that's how we come up with $575 as your pro rata share of that. $100 for the risk assessment and $420 in oversight fees, which is what it costs to be on probation at $35 a month times 12 months is $420. That comes to a total of $1,720. Mr. Stanaway, sir, are you in a position to pay that, or are you going to need a payment plan?
I'll probably do a payment plan.
How much can you realistically afford to pay on a regular monthly basis?
If you divide that by 12, I should be able to pay that.
Okay. But dividing that by 12 is $143.33.
Okay.
Are you actually working now?
Yep. I work 2 jobs.
So what I'm going to do is I'm going to say $100 per month.
Okay.
And I'm going to start you next month. So your first payment will be due on November 16th. So that will give you a whole month to come up with your payment. And I am not doing this because I'm a nice guy. I'm doing this because this is a court order. You don't make your payments, you go to jail. So that's why I want to make sure that it isn't a amount of money that you can afford to pay. Okay? So if something happens and you're not able to make your payment, you need to come see me before your payment is due. So whatever the 16th day of that particular month happens to be, you need to come see me. You need to come to the courthouse. You cannot call me. You can't send me an email or a letter or a text. You have to actually physically come to the courthouse and ask my court officer to get you in front of me. If I'm not available, then you need to see Ms. Williams in the clerk's office. Okay? You don't have to remember her name, just you know you need to see the lady that handles payments on behalf of the court.
Okay.
Okay? You fail to do that, I do a bench warrant, there's an automatic $75 charge that is applied to your account and the cops are looking for you. There's also the possibility of you having a 20% late penalty as well.
Okay.
All right, you to meet with probation on a monthly basis, or as directed, I'm gonna make you eligible for early discharge. That means that you can end your probation up to 6 months early if you're in full compliance with all the terms and conditions, and I'm satisfied that the goals of rehabilitation have been met. I'm going to assume that you can stay out of trouble. I'm not going to assume that you can convince me that the goals of rehabilitation have been met. You would have to have a meeting with me. We would have a hearing, and I'd have to ask a lot of questions of myself to determine that I think that all things that need to be taken care of have been. So it's not a walk in the park for you to be able to convince me that you should have an early discharge of your probation. You can actually be on probation with me for up to 2 years. But at this juncture, I'm going to assume that you can get this done in a year or less. Okay?
Yes, Your Honor.
All right, so you're not to possess, carry, use, or purchase a firearm, ammunition, or other dangerous weapon. Do you own any weapons, sir?
No.
You're not to violate any criminal law of any unit of government, not leave the state without the prior consent of the court. You're to make a truthful and accurate report to the probation officer at each contact. You're to notify probation within 24 hours of any change of address or employment and school status, and within 24 hours of any official contact with the police. So if there's official contact with the police, you need to report that by the next business day. Otherwise, that is a probation violation for which you would go to jail. You're to provide proof of healthcare coverage or meet with the healthcare navigator as directed by probation. Not to use, possess, consume, or be in the presence of alcoholic beverages or controlled substances, nor be present at any place where alcohol is sold for consumption on the premises. You're not to use any products that contain alcohol or some other substance that would change your state of alertness, including poppy seeds. As I said before, probation is about rehabilitation. Rehabilitation cannot be accomplished if you're in environments where it's going to compromise your ability to be rehabilitated. So as I said a moment ago, you can't be around people that are drinking. One of the things that is undergirding this situation is probably helped to lead to was liquid courage. That you were drinking and that encouraged you to lower your inhibitions to do things that you should have been doing. So you can't be around people that are drinking and you can't drink. So you cannot go to a bar even if you don't have any intentions of having a drink. So for example, we've got Michigan State coming up for football this weekend. You can't go to the bar to watch the game even though you don't have any intentions of drinking. But
Yes, Your Honor.
being around people that are drinking is not a rehabilitative environment. Understood?
Yes. Yes, Your Honor.
So no going to the bar to play cornhole or to shoot pool or to play darts or to do anything. As a matter of fact, if you walked into the bar to go and pick up a hamburger, take on with you, you're in violation of probation just by walking in the door of the bar. Same thing would apply to going to a place like a bowling alley or a concert, going to a wedding reception, going to a friend's house for a party, going to restaurants like Red Lobster's, Applebee's, or Chili's. You want to go to some place like that, you want to be in an environment where people are consuming alcohol, you better have permission from your probation officer in advance before you do that. Not only can you not be around people that are drinking, you can't be around people that are using controlled substances. And marijuana is still a controlled substance. And even though the law has changed so that people over the age of 21 can legally possess and use marijuana, that would be a violation of your probation to be around them. As a matter of fact, I treat alcohol and marijuana the same. You can't be in a bar or places where people are drinking. You can't be around people that are smoking weed. having you exposed to secondhand smoke. It's not my idea of a rehabilitative environment. And even if they had edibles and there weren't any smoke in the air, it's not a rehabilitative environment for you to be hanging around people that are getting buzzed off of brownies. And obviously, if you can't be around people that can legally use controlled substances, you can't be around people that are illegally using controlled substances. You can't use any substance that contains alcohol or some other substance that would change your state of alertness. That would mean that you would have to be on alert for places where alcohol is hidden at. So it's hidden in a lot of things. It's in non-alcoholic beer. It's in things like cold medications and pain pills. Well, not pain pills, but things that you do for like your gum aches and things like that, like Anbesol. Or some forms of toothpaste have alcohol in them. So you have to know what it is that you're putting into your body, because what you put into your body can be a violation of probation. So Listerine would definitely be a violation of probation because it contains alcohol. There's alcohol in beverages like Mike's Lemonade, these Twisted Teas and seltzer waters, and even energy drinks like Plea. And it's just not limited to those forms of alcohol. It can actually be household products. People have been known to drink stuff like hand sanitizer and rubbing alcohol, even sternal fluid. People have actually continued to snort things like glue and gasoline, duster to get high. So it doesn't matter if it's a household product. And as I said about edibles, that would apply to you as well. So brownies, cookies, gummies, granola bars, suckers, dabs, wax, vapes, K2, Salvia Spice, 221 Cloud 9, potpourri, or whatever. And it doesn't matter what they're calling it. You need to know what it is that you're exposing yourself to, because it can and will be a violation of probation. In addition, you're not to use prescription and non-prescription drugs and provide verification of all prescriptions to your probation officer within 48 hours of obtaining the prescription. You are to attend counseling. You're going to do cognitive thinking, or cognitive behavior thinking, I guess is what they really call it, anger management as part of your probation. You're dropped for probation, law enforcement testing agents, case manager, physician, and counselor. You are to have no contact with Sarah. You're not to be on her property. You're not to assault, harass, intimidate, beat, molest a woman, or threaten any person. And you to keep domestic peace. And as I said before, if you, I'm sure that you heard me say this to Sarah, you send her an email, a letter, or a text, any form of communication, you call her, any kind of communication, that will be a violation of no contact provision. Even if she were to reach out to you, you avoid contact with her. You look on your phone, you see her number on your caller ID, don't answer it. Because if you answer it, you have still made contact with her. Even though she initiated it, you'll be the person on the way to jail. So you avoid all contact with her. I'm making myself clear.
Yes, Your Honor.
You're dropped for probation, law enforcement agents, testing agents, case manager, physician, or counselor. You submit to a search of your person, your home, or your car upon the request of the probation or law enforcement officers who have cause to ensure that you're in full compliance with all of your probationary terms. That you place on electronic monitoring. And at this date, I am not placing you on electronic monitoring. But if you get placed on electronic monitoring, it does have GPS capability. It'll tell us whether you're in compliance with all of the terms and conditions of your probation in terms of geographic limitations as well as your curfew. 5 days community service by the end of probation, which is 40 hours. And you'd have an 11 o'clock p.m. curfew. You're to maintain employment as condition of probation. I think your license is still going to be subject to suspension. I think you got 6 points as a result of the reckless driving, so that could cause your license to be suspended. In addition, you're to submit to fingerprinting by law enforcement as directed by probation. Now, despite the fact that I've ordered all these things, you may be able to appeal. If you decide to appeal, you need to do so within 21 days. If you require the services of an attorney to help you with the appeal, and you can afford to hire your own attorney, then you need to make sure that the court knows that within 14 days, so we can contact the public defender's office and they can evaluate your eligibility for appellate services. So, sir, you are now on probation with me as of this moment. Understood?
Yes, Your Honor.
Sir, do you have any questions or concerns?
Just when do I report to the first probation, or do I wait for mail?
You just wait for them. They'll get in touch with you hopefully by the end of the week, and if not by the end of this week, that'll be the beginning of next week.
Okay.
Ms. Nichols, any questions or concerns?
No, Your Honor, thank you.
All right, then that's going to be all for the record. You are free to disengage at this point.
Thank you, Your Honor.
Thank you.
So.